where you know you need to be.
Yes.
You know that is a major issue with your situation. All these cases that are before the court, whether they're being taken into consideration or the ones that the judge has to rule on and make a decision what happens to you going forward, alcohol is a major issue that you need to confront. You understand that, correct? And you are doing that.
Yes.
And you're doing that successfully, correct?
Yes.
Questions, Judge?
Yes.
Can I call Mr. Marquez? Can I call you Charles?
Yes, that's fine.
Okay. All right, Charlie. Well, first thing, let's just be honest right now, because honesty is the best policy.
This right here is the foundation of the entire case. When a judge identifies substance abuse as a major issue, everything else, custody, probation, sentencing, gets viewed through that lens. The question isn't just, did he mess up before? It's, can the court trust him going forward? Do you think he's being fully honest here, or just saying what the court wants to hear?
If you're dishonest, we're going to snip out right here, so just be upfront with my questions. All right, let's talk about Crystal. How long were you in a relationship with her?
No, we've been married over 14 years.
Okay. Are you living with her right now?
Right now, she's currently employed and out of the house. But with
But you're not under the same roof.
Yeah.
Just listen to his
All right.
question.
Yes.
Okay. All right. Let me ask you, did you ever contact her?
we have we have to be in contact only for the visit for the kids.
For the kids? Okay. How many kids do y'all have together?
We have two.
Two? Okay. Boy, girl?
You got two boys.
Okay. How old are they?
One just turned 13, the other one is 10.
That's going to be a ripe age for two boys, man. Right?
Yes.
Okay. Let me ask you, so when you're communicating with her, did you ever tell her about not talking to the DA's office?
I went to the evaluation last week and I told her she was supposed to call, I forgot his name, Doug, to about a statement.
Okay, and
probation.
is that the, have you ever heard of something called an affidavit of non-prosecution?
No.
Okay. All right, let's talk about, because...
Quick legal breakdown. An affidavit of non-prosecution does not automatically make a criminal case disappear. Prosecutors can still move forward if they believe there's enough evidence. A lot of defendants misunderstand this, and that confusion can seriously hurt them later in court.
We've got a few cases, one of which is involving Crystal. So let's talk about the first one. Did you get deferred adjudication for an assault family violence?
For the first case, yes.
Okay. Was that with Crystal?
Yes, correct.
Okay. What about the second case, Matt?
That's also with her.
Okay. Let's talk about, so I was reading the PSI. You were saying in there that you had no alcohol problem, right?
Yeah, because, yes, correct.
Okay. But you also said that your alcohol use has increased over time?
After my brother passed away, it's been a year this coming week that he's been passed.
Okay. Have you tried to stop using alcohol?
Yes.
Okay. Have you been successful?
Somewhat, but I do notice that I do have a problem.
Okay. What do you mean by somewhat? Did you go for a little bit and then fall off the wagon?
Yeah, because like I said, it's been just a year and my brother passed. It's been hard on our family.
Okay, I get it. Was your alcohol use a factor in that evading with the vehicle that you got back in July 26th, 24th?
No.
Were you intoxicated that night?
I made it home, got out, and they never blood tested me when I got into the Fair County.
Okay.
And I had alcohol in my system.
Did you stop for the police?
I had stopped the light. He pulled over next to me, but he never turned on the light. I was waiting at the light. It turned green. I turned, but he never pursued.
Okay, so why is there an evading with the vehicle then?
They caught me in my apartment.
So you drove. So the couple of next to you, and then you drove home.
I turned at the light whenever the light turned green.
Okay, Matt. Let's talk about March and April of last year. How many cases did you pick up during that one?
I think it's 2.
So let me walk you through it. So on March 12th, 2025, You got a case for possession of controlled substance, PG1, 4 to 200 grams. A week later, you got your second assault family violence with Crystal.
This is a huge red flag. 3 felony cases in roughly 30 days, including family violence. Tells the court this wasn't a one-time mistake, but a pattern. Judges look at timelines like this very closely. What do you think was really happening in his life during this period?
And then on April 2nd, you got a PG1 less than a gram. So within a month, you picked up 3 felony cases, one of which was violence. What was going on?
I was trying to go take our kids to school for the family, the violence, and I called the police, and I ended up getting a warrant for my arrest, and I turned myself in.
Okay. You have a problem with substances?
Not no more.
Okay. What was going on? What kind of substance did you have that month in March and April?
It was cocaine.
Okay.
Yes.
I think on your PSI you said you used cocaine when you were 18, but you didn't bring up that you were using cocaine last year. Why was that?
I just said I didn't.
This is where credibility starts to crack. Courts hear the "it wasn't mine" defense all the time, but inconsistencies matter more than explanations. Once a judge doubts your honesty, every statement after that gets scrutinized harder.
So I had told them on the possession that somebody was in my car and they left their bag in my car.
You think when you're talking to the interviewer, it's important to be upfront with them?
Yes, I did state that somebody left bags in my car.
But now you're telling them that you haven't used cocaine since you were 18, but you just admitted that you had it on you last year.
I wasn't doing it.
What were you doing with it then?
I was for my friends, and I was in my car.
So it wasn't your coke, it was somebody else's?
Yeah, correct.
Okay. That's what's good.
You've been tested for us at Center with CPS. Is that right?
Yes.
And have they tested you for drugs and alcohol?
Yes, correct.
And they've all been negative. You have not used cocaine or any of that while you've been seen by CPS, correct?
Correct.
And if they tested you today, you would be negative, correct?
Yes.
Okay.
Just had a drug test last Friday.
Do you think you could be successful if the judge put you under supervision of her probation officers, putting you through additional programs like you're doing now with CPS? Do you think you can? Are you willing to do that? Can you do it?
Yes.
Why do you say that?
I'm the main supporter for my family, and there's no income coming in for either the kids or my wife.
What do those children mean to you?
They mean everything. They're the only 2 kids that I got.
You realize if the judge does put you under court supervision, any violation, if you would come back in front of her, I guarantee you it would not be good. You understand that?
Yes.
Do you still want the judge to grant your application for community supervision?
Yes.
That's messages.
All right, this is what I want to know. And if anyone wants to answer the question, great. If no one wants to answer the question, that's great as well. I am trying to understand. One, he stated to me that for the CPS case, the children have not been placed with the mother, who's listed as the complainant in this case. Children are placed with his mother. And that usually suggests to the court that there's some issue. Now, I know sometimes people will stand before me and say, oh, I lost my children because my partner was abusive or something like that. And usually that doesn't happen. So I'm trying to decipher and read between the lines what's going on here, because the state's stipulated evidence that everybody agreed to, we have some incident that occurred after his workplace. So I'm trying to figure out, how do we get from she goes to see you where you work, and I'm assuming, I don't know if the children arrive with her or not. Everything is fine. Your new girlfriend or wife or whoever she is shows up, informs her that she's expecting. According to the stipulation, she said it was a great conversation. And then we have you going to the mother of your children's apartment, and confusion results. And I'm just saying confusion instead of saying everything, but I reread the steps. And they're saying this happened at 7:50 on March 18th. What day of the week was that?
Which year, Judge?
2025.
What day, Judge?
March 18th, 2025.
That'd be a Tuesday.
All right. So his testimony was that he was going over there to take the children to school. Was his testimony? I think that's what he said.
So
All right. So I'm just trying to figure out credibility here. So being at that apartment at 7:50 on March 18th, maybe he was there to take the children to school. I don't understand how we get from you're there to take the children to school to this incident happening, and then you're leaving the location. Were the children taken to school, or did you leave the location without taking the children to school?
I left the location without taking children to school.
All right. And so there is a lot that's missing from the stipulation that I would like answers to, but it was still sufficient enough to find you guilty of the offense. So how long have you been involved with Child Protective Services?
For a year already.
All right, over a year. So your rights have not been terminated? Did they give you an extension?
I got a court date in April, and the deadline is for May. About May.
All right. And so the mother of the children, do you know whether or not, because I know y'all will probably go to court together, do you know if she's completing her service plan?
Yeah, she's doing her services as well.
Okay. And outside of court, have you had any, and when I say outside of court, outside of the CPS court hearings, have you had any contact with her?
Just to pay bills, basically. But she's not employed.
Okay. And when you say the pay bills, what bills do you mean?
Cell phone, groceries, food, whatever. She has basically homeless without me. So she has no source of income.
All right. And what does your new wife or girlfriend say about that?
I don't no longer talk to her anymore.
No longer talk to who?
The friend.
Her name?
No, I mean the new woman that was in your life that's in the stipulations.
Yes, it was just a friend from an employer.
But it says she's pregnant. No, in the stipulated evidence, it says this new girl shows up, tells the mother of your children that she's pregnant with your child.
Mm-hmm.
And according to the stipulations, the mother of your children said it was a good conversation. Everything was fine. She leaves, and then you show up at her home on Tuesday. What you say is to take the children to school. So where is that person?
I don't know. She just calls me every once in a while, but she's not pregnant.
Okay.
Yeah.
Judge,
Yes.
let me ask a few more follow-up questions of Mr. Marquez.
Yes.
All right. So, Mr. Marquez,
This moment is devastating legally. Violating a no contact order, especially on the record, can completely change the judge's tone. Even if the intent was financial support, the law doesn't care about intentions here. Do you think this admission sealed his fate?
So this new assault family second charge is against Crystal, right?
Correct.
And you said you're not living with her?
Right now she's living at my apartment.
I'm sorry, what, living where?
She's living at my apartment where I'm paying.
Okay, she's living at your apartment.
So you are in contact with her?
Like I said, I have to. Yes, I have to, because I have to pay the bills.
Okay. Judge, we'd like to show you the conditions of bond in the assault family second that we were talking about with Miss Crystal Vasquez. And on there, it explicitly says that there is a no contact order in place between Charles and the person named here. So he's just admitted on the record to you to violating his conditions of bond.
All right.
I do have another lawyer for CPS case. He supposedly picked up the violation for the no contact order.
All right. So who's that attorney?
I gotta look up my phone. So we do have anything.
Dale Hill.
All right. So we're going to take a short recess, and this is what I want attorneys to find out. It should be easy to find out. If somebody can call Dale Hill, or if somebody can have a CPS caseworker Zoom in here, because I want to see if what he's telling me is the truth regarding where he is in the CPS case. Because I would regret to leave children unsupervised, or they're going to be in foster care or something of that nature would happen if people have changed. So if somebody can get in touch with Dale Hill, get in touch with the CPS worker, and if there's no objection to them zooming in.
I'll just get the Zoom number from
All right,
the clerk,
thank
and I'll
you. And then I'll take this matter up.
have a seat.
1 minute, 37 seconds later.
R015638 and 2025 CR01263, State versus Charlie Marquez. Can I have parties re-announce?
Brandon Brady for the state.
Warren Wolf, Mr. Marquez.
And you're Mr. Marquez. All right. We were not on the record, but we did have Mr. Marquez's CPS attorney zoom in. And as an officer of the court, he presented the court and both parties with updates on the CPS case. And according to his rendition, Mr. Marquez is in compliance and that the children are residing with the paternal grandparent. All right. So this is what I want to stress to you. There is a no contact order, and the no contact order is in force. The only exceptions usually for a no contact order is if you are in court. So that is the only contact you can have. And you can pay bills for an apartment that somebody is staying in without having contact. You either send it by check, money order, but you do not need to go to the location. You can pay any type of utilities. And the last time I lived in an apartment, I think sometimes the utilities are included with the payment or it may be separate. But if your name is in the utility bill, you can pay that online. You are not allowed to contact her outside of being in your CPS court hearings. Do you understand?
Yes.
If you do that, you will violate any probation that I give you. And then you're looking at doing time. And when you're looking at doing time, maybe your parents will be able to take care of your children, maybe not. They may end up with their mother. And somebody else, some other man will come in to raise them. Do you understand?
Yes.
Judge, would you be willing to entertain a motion to modify that no contact order?
No.
If that's the solution, I can do that.
Yeah, no.
8 years, suspended and probated. This is the court giving him one last structured chance. But with GPS monitoring, strict conditions, and zero tolerance for contact violations, this is a razor-thin line. One mistake, and prison time becomes very real. Do you think probation like this actually helps rehabilitation, or just delays the inevitable?
All right. So this is what the court is going to do. Let me see. I'm trying to find your application. Did he apply for deferred adjudication? Just regular? All right, this is what the court is going to do then. End cause number, Odyssey again, 2025 CR 015638. Probation, are you ready? Court is going to is finding you guilty. Court is going to sentence you to 8 years in the prison, suspended and probated for 8 years. Regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 45 days. No employment as a home health care provider or with minors. There's to be CPS compliance. There's to be no contact with the complainant. There's an affirmative finding of family violence. There's going to be GPS tracking, waive fees. That is to be installed no later than February 10th, 2026 at 3 p.m. This will run concurrent with 2025 CR 012673. 2024 CC 737959, 2025 PF 09446, taking consideration 2025 CR 011814, 2025 CC 005. That is correct. When is your surgery?
13/30/13.
All right. So the GPS is to be installed after clearance. After medical clearance.
Thank you.
All right. And then there's to be the BIPP course.
I think he's already either taken it or enrolled.
All right. He'll need to provide proof of that to probation. And probation, he's currently in a family violence course. That family violence course will be acceptable to the court. You are not to go to your other apartment. If that apartment is in your name and you're paying bills and you're being nice and allowing her to live there, you can pay that bill, send it in to the apartment complex. You can pay the utilities online, but you are not to have any contact with her while that protective order is in place. Do you understand?
Yes.
Is there anything you do not understand? All right, good luck to you.
Thank you very much, Judge.
Thank you. Oh, do I have the cases that were taken in consideration?